I want you to pause for a moment and imagine this. Not a war zone, not a battlefield, but a courtroom in the United States where the Constitution is supposed to mean something. 137 people were put on planes, flown out of federal jurisdiction, and stripped of their most basic right, the right to be heard. No charges, no judge, no due process. Just disappearance, first to El Salvador, then to Venezuela. And now, when a federal judge demands accountability, the government's answer is not law. It's chaos. The situation is fluid. Things changed on the ground, as if disorder itself were a legal defense. I've spent my life studying systems, economic systems, political systems, moral systems. And I can tell you this. When a government starts using confusion as strategy, something far deeper is breaking. If you care about the rule of law, stay with me. Because this story is not about 137 people. It's about what happens when power decides it no longer needs permission. And here's where it truly begins. Let me be very clear about what this case is and what it is not. This is not a technical dispute between lawyers. This is not a paperwork problem. And it is certainly not a question of timing. This is a direct collision between executive power and constitutional limits. On one side, a federal court asserting something foundational, that no government can disappear people beyond the reach of law. On the other, an administration arguing that because it created chaos abroad, it now deserves more time at home. That logic matters. Because once confusion becomes a governing tool, legality becomes optional. Habeas corpus turns into a suggestion. Due process becomes conditional. And notice the pattern. When ordered to stop, the planes kept flying. When asked to explain, the answers grew vaguer. Fluid, unfolding. Words designed not to clarify, but to exhaust. You don't need a law degree to understand what's happening here. You only need to recognize a system testing how far it can go. And to understand why this didn't start in January, we have to go back. To understand how this became possible, we have to look beyond this courtroom and into history. In moments of fear, governments always reach for the same tools. Emergency powers, exceptional laws, language that turns people into categories instead of human beings. The Alien Enemies Act was born in that tradition. A law designed for wartime panic, not modern constitutional governance. It was meant to be rare, temporary, dangerous if misused. But here is the pattern history teaches us. Extraordinary powers never disappear on their own. They wait. And when politics aligns with fear, they are revived not as protection, but as shortcuts. What we are seeing now is not improvisation, it is a cycle. Label first, remove process second, justify later. Once the executive decides that speed matters more than law, every safeguard becomes an obstacle. Courts become inconveniences, judges become enemies, and people become cargo. That's how you reach a moment where planes keep flying after court orders say stop, where jurisdiction is treated like something you can outrun. And inevitably, when power moves that fast, something breaks. That break came suddenly, and it came with consequences. The first real fracture came when the court said one word that power hates: stop. Stop the planes. Stop the transfers. Stop removing people from judicial reach. And yet, the planes kept flying. This is the moment where legal debate ends and constitutional crisis begins. Because ignoring a court order is not interpretation, it is defiance. And defiance, when repeated, becomes precedent. A federal judge didn't just object, he asserted jurisdiction. He warned, he documented. And when the executive branch moved anyway, the question was no longer procedural, it was criminal contempt. What followed exposed the mechanics of the system. Orders were treated as suggestions. Judges were framed as obstacles. And responsibility dissolved upward. No one accountable, everyone moving fast. And notice how this crisis was managed. Not with transparency, not with explanation, but with momentum. By the time anyone could react, the people were gone. That is how modern power operates. It doesn't argue openly. It overwhelms. It creates fates, accomplice, and dares institutions to reverse them. And when the system hesitates, power learns. What it learned next would be used again. Here is the mechanism most people miss. This was never about logistics. It was about jurisdictional escape velocity. Once people are moved outside the reach of U.S. courts, the law slows down and power speeds up. Habeas petitions become complicated, hearings become abstract, responsibility becomes blurry. That is not an accident. It is design. Notice the sequence. First, remove people physically. Second, argue that distance creates impossibility. Third, ask the court for time not to comply, but to recalibrate the narrative. This is where words matter. Fluid, unfolding, changed circumstances. These are not descriptions. They are shields. They turn deliberate actions into acts of fate. And when a government claims that chaos it created now prevents compliance, it is testing a dangerous idea, that legality dissolves once complexity is high enough. If that logic holds, any executive can outrun the Constitution simply by moving fast and far. Courts become reactive, rights become conditional, and delay becomes policy. That is why this case matters beyond the courtroom. Because once this mechanism works once, it doesn't stay isolated. It gets reused. And the next moment would prove exactly how far this logic was willing to go. The second crisis arrived disguised as foreign policy. Suddenly, Venezuela entered the courtroom, not as context, but as excuse. The government argued that substantial changes on the ground made compliance difficult, that the situation was fluid, that time was needed. But listen carefully to what that means. The executive branch removed people from judicial reach, then altered the geopolitical landscape, then asked the court to adjust to the chaos it created. This is escalation, because now the argument is no longer about law versus speed, it is about law versus force. If military action, regime collapse, or foreign custody can suspend constitutional obligations, then rights exist only when geopolitics allow them to. That is a profound shift. The court was not persuaded. It didn't ask for explanations. It asked for solutions. Either bring the people back or provide real hearings that satisfy due process. And notice how narrow that demand is. Not punishment, not theatrics, just law. Yet even that basic demand was met with hesitation. More time, more uncertainty, more fluidity. At this point, the crisis is no longer about Venezuela. It is about whether courts still have the power to command compliance or only to record defiance. And now, the consequences move closer to home. Now, I want you to think about this from the human side. Imagine being taken without warning. No hearing, no chance to speak, no lawyer standing beside you. Just a plane, a destination you didn't choose, and silence. You don't know where you are in the system or if you're in it at all. That is what the erosion of due process looks like in real life. Not abstract rights, not legal theory, but uncertainty that never ends. And here's the uncomfortable truth. If this can happen to them, it can happen to anyone once the rules become optional. Rights don't disappear all at once. They fade for the least protected first. This is why these cases matter. Not because of ideology, but because they test whether law still protects people when power finds it inconvenient. If this story unsettles you, it should. If it makes you uneasy, stay with me. Because awareness is not passive, it is the first defense. Share this, talk about it, pay attention. The cost of silence is always paid later. And beyond these individuals, the shockwaves don't stop here. What happens inside one courtroom rarely stays there. When a country that claims to champion the rule of law begins treating due process as optional, the signal travels fast. Allies watch, rivals take notes, and authoritarian governments feel vindicated. Because the message sounds familiar: security first, rights later, or never. When detainees are moved across borders to escape judicial oversight, it normalizes a dangerous precedent. Other states learn that legality can be outsourced, that accountability can be delayed by geography, that chaos can be weaponized. And this matters in a world already strained by conflict, migration, and power competition. Once law bends for convenience, cooperation fractures, trust erodes. Every extradition, every treaty, every promise becomes suspect. Notice how quickly the language shifts from constitutional obligation to geopolitical necessity, from individual rights to strategic interests. That is how legal norms dissolve, not with an announcement, but with repetition. If the strongest systems demonstrate that courts can be sidelined when power moves fast enough, weaker systems will do the same more brutally, with fewer constraints. This is not just a domestic test. It is a global one. And where this leads depends on what happens next. From here, the system faces three possible futures. The first is restraint. Courts hold. Orders are enforced. The people are returned or given real hearings, not because power wants to, but because institutions still can compel it. This is the best outcome, not because it is perfect, but because it proves limits still exist. The second is erosion. Compliance arrives slowly, partially, wrapped in delay and technicalities. Rights are acknowledged in theory, weakened in practice. The system survives, but thinner, more fragile. And then there is the third path, the most dangerous one. That is normalization. Defiance becomes routine. Extensions become endless. Distance becomes defense. Courts speak, but power moves anyway. Over time, people stop expecting enforcement, and that expectation matters more than any single ruling. History shows us this pattern clearly. Democracies rarely collapse overnight. They hollow out. Law remains on paper while practice shifts elsewhere. Which future emerges depends on whether this moment is treated as an exception or as rehearsal, because systems learn. Power learns. And once a boundary is crossed without consequence, it becomes a suggestion the next time. And that brings us to the question that cannot be avoided. Every generation faces a moment when law is tested not by words, but by power. This is one of those moments, not because of who is in office, not because of ideology, but because the question is brutally simple: does the Constitution still apply when it becomes inconvenient? If courts can be ignored when planes move fast enough, then rights exist only on paper. If delay becomes policy, then justice becomes optional. And when confusion is rewarded, it will be used again. I have spent decades studying how systems fail. They don't fail loudly. They fail quietly when enforcement hesitates, when exceptions multiply, when people assume someone else will stop it. That assumption is always wrong. The rule of law survives only when it is insisted upon, watched, defended, repeatedly. If this story matters to you, don't treat it as background noise. Stay informed. Share it. Demand accountability, not theatrics, not slogans, but compliance. Because once a system learns it can move without permission, it rarely asks again, and the next time, the line may be even easier to cross. Stay with me. There is more to uncover